Hi everyone, welcome to the module 2 of our IPR series. We'll be discussing copyright law today. So in this module, we are going to explore how copyright protects the creative works, be it books, music, art, or films. We'll also be discussing why it matters in our rapidly evolving digital age. We'll also try to understand the basics, the legal provision, the key rights it confers, and most importantly, how it safeguards the creators in India. So let's start with the historical background. So it is under the British rule that India adopted the Copyright Act of 1847, and it entirely was modeled on the British norms. However, later in 1914, we had a revised version. But the real transformation, it actually came with the Copyright Act of 1947, which we still follow today. Now, this act has gone through the amendments in 1994 and 2012. Now, each of the amendment, it has modernized the copyright and to such an extent that it has made it adaptable to the changes like the digital content and international obligations under the TRIPS. Now let's move ahead with the theories of copyright. First is your natural rights theory. So what this theory basically states is that the creators naturally own the work they create. So it reflects the ethical and moral right. Next is your utilitarian theory, which states that the copyright is not just for your creators. Now, this promotes public welfare by giving limited protection so society can benefit for more innovation. Now, next is your economic incentive theory. Now, what this sees copyright as is an economic tool. So it protects the creator and so that they can create more. So it ties your creativity with commercial gain. Let's move ahead with the legal definition of copyright. The same is covered under Section 14 of the Copyright Act. So as per Section 14, copyright is your bundle of exclusive rights granted to the creator of original work. Now, these rights can include like a reproduction of the work, adaptation into other formats, like novels into films, then communication to the public, and even translation into other language. So let's take an example. Suppose an author writes a novel. So she has a now exclusive right to either reproduce it, adapt it into a movie, and even control any translation. I mentioned a key case here, that is EBC versus DB Modak. So the court emphasized here that the hard work just isn't enough. There must be original thought or creativity involved. So here the Apex Court, it emphasized that the copyright does not protect mere sweat of the brow effort. Instead, it requires a modicum of creativity. Now let's move ahead with what kind of works get copyright. So section 13, it lists 6 broad categories. The first one is your literary works, such as books, blogs, poems. Then comes musical works, such as your compositions or lyrics. Then dramatic works, this could include scripts or plays. Artistic works, including paintings, photography, and drawings. Then are your cinematograph films or the sound recordings. However, I would like to point out that there's a crucial principle of expression versus idea. So only your expression is protected, not the idea. So there is a famous case, which is RG Anand versus Dlex Films, which talks about the same. So here, the Supreme Court, it stated that if two movies that are based on the same theme but executed differently, there is no infringement in that case. So the ideas are always free, but the expression, it is what is owned. Let's move ahead with the ownership of copyright. So it is dealt by Section 17. Now, according to the section, the author is the first owner. However, there are few exceptions, such as if a work is created during the employment or under a contract for company or the government, then the employer owns the copyright, or your copyright can also be assigned to someone else. So here is an example case of Najma Hepla. So here a biography was commissioned and the court ruled that the author retained the copyright because it was explicitly assigned otherwise. So you have to always check the contracts to clarify the ownership. Now let's move behind the rationale of copyright protection. Why does copyright exist? There are three main reasons. Firstly and foremost, it encourages the creativity. By granting the rights, creators are motivated to innovate. Then it rewards the labor, so it protects the hard work, time, and effort that is put in by the authors and the artists. Then it promotes the knowledge. So when you're creators, when you as creator, you feel secure, you will publish more. Now, this enriches the public access to culture, education, and innovation. So, copyright isn't just about the profit; it is also about balancing the private rights with the public interests. Now let's talk about the moral rights. So apart from your economic rights, author also have the moral rights. Now these could include rights of paternity, which is claiming the authorship. Then is right of integrity, that is preventing distortion or misrepresentation. And then lastly is the right to publish or withdraw. So it is to control when and whether the work is made to the public. These rights are independent and non-transferable, so they recognize that a creator's dignity is tied to their work. Now let's move ahead with how long does the copyright last. So honestly, it depends upon the type of authorship. If you're an individual author, it is the life of the author plus 60 years. In case of joint authorship, it is 60 years from the death of the last surviving author. In case of anonymous author, it is 60 years from publication. In regards to government works too, it is 60 years from publication. And lastly, in regards to photographs, it is also 60 years from when the photograph is made. So copyright, it ensures long-term protection, not just for the creators, but the legal heirs and the estates as well. Now let's talk about assignment and licensing. This is about how your copyrights are transferred. So it is dealt by section 18 and these are the two key ways. First one is assignment. So here your ownership is only transferred via some written agreement. Then is licensing, which gives the permission to use the work within certain terms without transferring the ownership. So a key case is Durga Das Basu, wherein the issue of licensing and usage rights came up. So it was reinforced that licensing must be clear and the terms must also be honored. So you can think of licensing as giving the keys of your cars to someone to use the car, but not actually selling the car. Let's talk about the recent developments in India. So first, there is the draft National IPR policy of 2024. It has proposed changes to streamline and modernize the copyright law. Then the 2021 intermediary guidelines, it has increased the accountability for your online platforms such as YouTube or Instagram for copyright violations. Then talking about the 2012 amendment, it has introduced protection for the performance right and for fair dealing. Here's also one key case that I'd like to point out, that is Saregama India Limited. Here, the Bombay High Court ruled on the interim broadcast rights and reinforced that the protection of sound recordings is requisite during your online broadcasting. So by wrapping this module up, I'd like to say that the copyright law in India is really a powerful tool. It protects the rights of the creators, it encourages original expression, and also it ensures a balance between your private ownership as well as the public access. If we see ever since the British era legislation, it has evolved a long way and it has now come to a modern adaptive framework. And even with the digital platforms or even AI generated content or the online piracy, it has come a long way. And the scope of this copyright law is only just expanding and evolving.